back in session.
You may be seated. All right, for the record, good afternoon. And I believe there were a number of exhibits that counsel from both parties agree should be admitted that were overlooked.
Yes, Your Honor, just two. State's Exhibit 116 and 117 that the state used with Mr. Bean. We'll submit those for admission without objection.
There is no objection, sir.
All right, those two exhibits will be admitted without objection. The next order of business prior to closing arguments, yesterday Attorney Cancel La Mesa indicated that she was going to ask this court to consider as a lesser included offense to count one, aggravated vehicular homicide, the subsection as it relates to the essential element of reckless.
Yes,
Attorney Cancel La Mesa.
Also with...
As to count two.
Count two. So, Your Honor, this argument will be made based on both of those counts. According to State v. Dean, an offense is an inferior degree if the indicted offense where its elements are identical to or contained within the indicted offense, except for one or more additional mitigating elements which will generally be presented during the defendant's case. In this case, because of the type of driving pattern we have and the type of evidence we have, if the court were not to believe or not to find that the state proved beyond a reasonable doubt the elements of OVI, that simply that he was impaired by any amount of alcohol to the point where he couldn't operate his vehicle in a safe manner, the state would submit that a lesser included offense of the aggravated vehicular homicide is the reckless A2 section, saying that the defendant did operate this watercraft recklessly and caused the death of Neil Brian Cuppet on that day on May 9th. Now, this State v. Dean analogy has been used throughout the state, and it says that an offense may be a lesser included offense of the other if the offense carries a lesser penalty than the other, which the A2 section, the reckless section, does in both of the statutes. And the greater offense cannot be statutorily defined, ever be committed without the lesser offense as statutorily defined also being committed. And some element of the greater offense is not required to prove the commission of the lesser offense. We already talked about the OVI. Obviously, the A2 section, we don't have to prove the OVI to prove the recklessly caused the death of. Now, both the statutory elements of the offenses involved and the evidence supporting the lesser included as presented at trial.
Can you slow down for Kathy?
Is grounded primarily in the need for clarity. That means it's an abuse of discretion standard, Your Honor. You can simply sit and listen to the evidence and determine that when one of those elements aren't met, you can decide that it is a lesser included offense. Now, although recklessly is not in the A1 section, it is a strict liability crime that OVI involves. Recklessness is inherent in a DUI claim because, according to State v. Stinson from 1984, there's some part of being this heedless indifference that recklessly involves as a definition is grounded in this person who drinks to the point of impairment and then gets behind the wheel. That's inherently reckless according to the law. And I could put those cases on the record, Your Honor. That case says evidence that the defendant was driving under the influence of alcohol is sufficient to support a finding of recklessness. Now, that is an appellate court case from the 9th District, 21 Ohio Ave. 3rd, 14. And the original case that I was speaking of before about that lesser included offenses is a Supreme Court of Ohio case in 40 Ohio State 3rd, 205. Now, as you recall back some years ago, you also tried State versus Martin Eberth. And that case looked at the lesser included offense of sexual battery as a part of the rape. The court went on to, because of course the defendant appealed that, the court went on to analogize that as a lesser included offense of rape, and it found that even though some of the elements were slightly different, because you sat as the trier of fact and were able to determine that it did fit the lesser included offense, it met all the State versus Dean elements, and it was affirmed that it was a lesser included offense. And that, for the record, is from our 7th District Court. It's 2008, Ohio 6596. Now, as another test that you could do to determine whether the recklessness is a lesser included offense of the OVI, aggravated vehicular homicide, you can look at whether they're allied offenses of similar import. Can you commit one without committing the other? Or do they happen at the same time? That sort of thing that you may analogize in those when you're determining sentencing standards for different crimes. Now, because the OVI is a strict liability as well, it doesn't have any kind of mens rea. When we don't have a mens rea in a crime, the fallback is always recklessness. That is, case law, there's tons of case law on that. I didn't bring one of those cases, but there are cases out there. I was looking for something that was directly on point with this. And it's hard to really find something that was directly on point. I did find some cases that talked about negligence being a lesser included. So I would think that you can analogize that if they're determining negligence as lesser included, then they should be determining that recklessness is also a lesser included.
Thank you. Attorney Morrow.
Thank you, Your Honor. The case which the state was just analyzing the lesser included issue, State v. Dean, was a 1988 case in the Ohio Supreme Court. And if the court will recall, through the 90s and into the early 2000s, the Ohio Supreme Court kept grappling with this lesser included standard and what it really meant. Do we look at it and analyze it strictly on the elements of the offense as contained within the statute? Do we look at it based upon the particular facts of the case? And there were a series of cases that came out from the Ohio Supreme Court after Dean that significantly muddied the waters on the Dean standard. It got to the point where the court was looking at case-specific facts. And finally, in 2009, they took a case, State v. Evans, and they modified it. And they said, we've gotten to the point where we've made this so it's not a workable standard. We've made it so it's arbitrary, so no one ever really knows if there's a lesser included or not. And in 2009, in State v. Evans, 122, Ohio State 3rd, 381, the Ohio Supreme Court said, we're modifying and clarifying Dean. Here's what's required to determine if something is a lesser included. 1, whether one offense carries a greater penalty than the other. 2, whether some element of the greater offense is not required to prove the commission of the lesser offense. And 3, whether the greater offense as statutorily defined cannot be committed without the lesser offense as statutorily defined also being committed. And here's where Evans modified Dean, and why the cases that the state has just cited to you construing the Dean standard through the 1990s and early 2000s aren't on point. Point number 3, Dean used to say whether the greater offense as statutorily defined can never be committed without the lesser offense. And in Evans, the court said that type of all or nothing approach is not reasonable. So the current standard in the state of Ohio for determining lesser included offenses is the 2009 State v. Evans Ohio Supreme Court case. There are, in fact, 2 cases that deal with whether or not aggravated vehicular assault has a lesser included under the reckless section. In State v. Honenberger, Hohenberger, a 2010 case, the citation is 189, Ohio Appellate 3rd, 346. The court was considering whether the reckless subsection for aggravated vehicular homicide, aggravated vehicular assault was a lesser included. And they concluded it was not. They acknowledge that some elements of aggravated vehicular assault and vehicular assault are identical. However, vehicular assault requires an additional element of recklessness, whereas aggravated vehicular assault requires the defendant to be under the influence of alcohol or drugs, and it is a strict liability offense. An individual can be reckless without being under the influence, and an individual can be under the influence without being reckless. Honenberger court said, "We agree with the Second Appellate District and their reasoning because an individual could possibly commit an offense under A1A without necessarily committing an offense under A2B. Vehicular assault is not a lesser included offense of aggravated vehicular assault." That was a 2010 case. In 2012, the Adams County Court of Appeals addressed the same issue and adopted the same reasoning. There are different elements, with regard to A1 being under the influence, that you could do that without being reckless, and vice versa. You can be reckless without being under the influence. So those two cases address the aggravated vehicular assault cases. I agree with the state. There did not appear to be anything directly on point that I could find addressing aggravated vehicular homicide. But the two sections are identical between aggravated vehicular assault and aggravated vehicular homicide. So the reasoning from Honenberger and Hicks, I believe, would be applicable to the aggravated vehicular homicide statute as well. That you can be under the influence without being reckless, and vice versa. So under the Evans standard, we submit the reckless section is not a lesser included offense. There are cases out there that do say the negligence section is a lesser included offense for the aggravated vehicular homicide. With regard to the cases that the state cited on use of alcohol consumption to prove the recklessness, in all of the cases that I read, and I'm not sure if those two are, I know this, was it Stinson you said?
Yeah.
Those cases did not just have alcohol consumption, they also had testimony that supported some type of impairment, perhaps not sufficient to get to the OBI standard, but there was some other indications of reckless conduct beyond the drinking. So I do not believe the reckless section is a lesser included under the cases that I cited to you and the state Evans standard, and that applies in Ohio.
Thank you. Attorney Cantor-Lamesa, any response?
Your Honor, the court has looked at evidence in other cases subsequent to Evans, and they still find they use the Dean standard in State versus Campbell. They talk about Evans, but they still go back to the Dean standard. So Dean hasn't been overruled or negated by Evans. They're still looking at that standard. And if the court feels that there's enough to acquit on the greater offense and go to the inferior offense, it's that court's abuse of discretion we're looking at. In this case, we don't just have a DUI stop on the side of the road with field sobriety exercises. We actually have evidence of recklessness throughout this case, and that's why we put on that evidence to make sure that the recklessness was the erratic driving was the recklessness, and there's a crash in this case. So it's inherent that it's reckless in this case because of that.
If I could, with regard to the indictment, a defendant is entitled to defend charges in an indictment that have been determined by a grand jury to have found sufficient evidence to support. Months ago, we spoke at pre-trials about recklessness and discussed the fact that it wasn't in the indictment. If the state believed they had sufficient evidence to support bringing charges for recklessness, they very easily could have gone back to the grand jury and gotten an amended or superseding indictment to add those code sections to this indictment. They chose not to. They proceeded with the indictment as charged, and I don't believe they should be able to, at this point in time, seek recklessness.
So, I am certainly familiar with Dean. I have read it. I am familiar with State v. Evans and its modification of Dean. It's still a three-part test. I believe, as counsel has indicated, one of those factors was modified in Evans to clear up the confusion that Dean brought. There is one case that I found as it relates to the state's analogy to allied offenses of similar import, and that is a Supreme Court case, State versus Zima, Z-I-M-A. Citation as 102 Ohio State 3rd 61. It's a 2004 case, and it actually dealt with the offense of aggravated vehicular assault, driving under the influence, and it examined, again, not the issue on point, but the United States Supreme Court's decision in Blockberger as it relates to the state's ability to twice try a defendant, the issue of double jeopardy, and in Zima, the court found that the statute 2903.08A2 lists driving under the influence and recklessness as distinct predicate offenses and not as a lesser included offense, and went on to state, quote, when the Blockberger test is applied to a statute containing alternative elements, each statutory alternative should be construed as constituting a separate offense and analyzed accordingly. So what I am going to propose, although I do have some additional questions, I guess it's not often that I get to play appellate court judge too, but I'm certainly familiar that the Dean and Evans kept Part 1 in place, specifically whether one offense carries a greater penalty than the other. And as indicted in this case, clearly, aggravated vehicular homicide in Count 1 carries with it, I believe, a felony of the second degree. Under the reckless section, as indicted, it would be a felony of the third degree. There are scenarios where if there was a specific finding by the grand jury that there was a prior offense, that penalty would be enhanced. So scenarios arguably where both would be a felony of the second degree, although certainly not the case here. I'm just trying to think through this logically. Counsel has cited several cases, Stinson, that I would like to see before I make a final ruling. If there is no objection, again, the benefit of trying this case to the court and not to the jury is that counsel would have the opportunity to make the arguments that they would like to make, and prior to beginning deliberation, once I have an opportunity to review the respective cases and issue my ruling, I would begin deliberations as to whether or not the recklessness as to count 1 and count 2 is a lesser included offense, or whether it is a separate offense that would have required action by the Mahoney County Grand Jury to list that as a separate count in the indictment. Any objection to proceeding in that fashion?
No, Your Honor, no objection.
All right. Attorney Cantor may sit down.
Thank you, Your Honor.
Your Honor, on May 9, 2015, the defendant was under the influence of alcohol. He was impaired. Him, by his own testimony, had 5 drinks that day. 2 beers, 2 shots, and the start of another beer. He then killed Neil Brian Cuppett on Berlin Lake. He knew he screwed up, and he ran away. The state presented multiple witnesses. We heard from Jenny Cuppett, Bruce Lindemood, Lieutenant Nolan, Melissa Naney, Adam Krolka, Jennifer Kingsley, Todd Jones, Simon Four, Constantina Cover, Hayes Cover, Dustin Cease, Rachel Mace, Andrew Krogan, Christine Hammond, Stacey Violi, Susan Elliott, Dr. Dorothy Dean, Lieutenant Greg Johnson, John Gersh, Investigator Dave Ford, and Investigator Rich McCullough. Those were people, especially Mr. Lindemood, who were eyewitnesses to this event. Eyewitnesses to either before or after, or for Mr. Lindemood during. Now, it was clear from all the evidence that the defendant was the driver of the Bayliner on May 9, 2015. He self-admitted that he was the only one on the boat, so he was the operator. He consumed alcohol. He admitted to it. Was he under the influence? Did he have this impairment that we've been talking about? He did. He self-admits that he had alcohol. We have the video of him having alcohol at the bar. And they're not just the beers that he claimed to Lieutenant Johnson, but also 2 shots as well. The testimony of his friend saying he was on the dock afterward with a beer. Him admitting on the stand that he had started a beer on the dock. And remember, he's on the dock. He's at Ben's for an hour. He goes back to the dock with Andy Krogan and the rest of the crew for another 45 minutes to an hour. That's at least 3 beers and 2 shots within about an hour span, and that's the alcohol that we know of. We don't know what he had earlier, and we don't know what he actually had at the dock.
Objection.
I am certainly able to gauge what he testified to and what other witnesses testified to at the dock. You may proceed.
Thank you. Now, by his self-admission, he hasn't eaten since 6 o'clock that evening. And on regular occasions, he eats 6 hot dogs, and that day he only ate 3. There's an empty beer can in the boat when the boat is inventoried that night. We also have his driving pattern. He's driving reckless right out of the dock when he's trying to hurry up and get home to his wife. It's testified to by Adam and Melissa that he's going way too fast, getting out of that dock, in that no-wake zone, and they don't understand why he's going so fast. Now, the speed limit on the lake is 10 miles per hour at night, and the no-wake zone is even less than that. And he's making wake, and he's going way too fast already. By his own admission, he's going 25 when he gets out on the lake. That's 2.5 times the speed limit on that lake at night. So if we equate that to a car in a school zone, he would be going 50 miles in a 20-mile-per-hour school zone. And why do we think that school zones are zoned to 20 miles per hour? It's because children might run out in front of your car, and you want to be able to have that time, have that reaction time to stop your vehicle. Same reason that lake speed limit at night is 10 miles per hour because things come up. You don't see things. It's dark out. It is a lake. There's no reflective tape on the lanes. There's nothing to mark within the lake, any lighted buoys or anything like that, what's going on in that lake, except for the navigation lights of the other boats. Things come up fast, and you can't see them until the last minute. That's what Adam said. And that's right, things come up fast. And they come up even faster if you're doing 2.5 times the speed limit. Now, his reaction time is impaired. We know that because he didn't stop. He says, by self-admission on the stand, that he saw some bridge lights off in the distance when he was getting closer to the bridge. How is he able to distinguish shore lights from boat lights? He can't. He is impaired. His actions are impaired by going fast in this dangerous situation. He also, once this happens, yells at the other boat that he hit, arguing with Bruce about the lights, arguing with Bruce about what they're doing out there in the middle of the lake. They're in the middle of the lake. They're allowed to be there. They're fishing. And he doesn't stick around to find out where his buddy is, that Bruce keeps yelling, that we hear multiple witnesses say, I hear these people yelling out in the lake, someone's asking where his buddy is, they're yelling for help, and then I hear arguing. Multiple witnesses then see him driving from that crash like nobody's business. Full throttle, as described by some witnesses. Even Dustin sees, who's on the other side of the bridge, at the point that the defendant comes through that causeway, says, hey, that guy's going to kill somebody. Little did he know he already did. Luckily, we didn't have multiple crashes on that lake that night with the way the defendant was driving. His friends have to come all the way from High Oaks Campground towards the top of the map and go help Bruce Lindemood and Neil Cuppett try to get out of that water, but he leaves. He doesn't lift a finger. This doctor who went to Iraq, this doctor who's in a mass unit, this doctor who knows how important it is to triage and to immediately treat injured people, leaves the scene. He doesn't do anything. His mental processes are impaired. If he's such a great doctor, if he wants to help out, he would have stayed. But his mental processes are impaired at the time from this alcohol. He may even be distracted by the phone at the same time. Now, the defendant said he put the phone in the drawer and didn't look at it, and he's just listening to music. But the phone records show a different story. The phone records show he's on the phone at the same time. Now, the 911 calls from this crash, from the people on the bridge, from the fishermen on the other side of the lake, and other places, come in around 12:09 to 12:11. That's the time of the crash. They're not going to wait around 20 minutes for the defendant to get to his house to call 911. They call immediately. He's making bad judgments left and right. He's impaired. He's distracted. He's had alcohol. He's trying to get home fast. And he's driving 2.5 times the speed limit. And then, boom, what everybody hears on the lake. What some described as an explosion or a blown-up engine. He crashed into Brian and Bruce. He kills Brian instantly to within seconds. So hard that Brian's tissue, Brian's hair, Brian's teeth are still found on the defendant's boat after it's towed up to the ODNR barrage. Such violent force is used to hit that fishing boat that Brian's neck is broken. His vertebrae is separated from his skull, crushing his spinal column. Leaving also, as you'll see from the coroner's report and the coroner's photos, which you probably remember from the testimony, a bruise on his left shoulder and across his chest. Now remember, even his defense witness had to say that the bayliner sat higher than the fishing boat. And Brian, as you remember, sat at the front of that fishing boat. It's moving so fast across the water that the victims in the fishing boat don't even have time to react to it. Because remember what Bruce said. He says, Brian says something about, look at this guy coming, and as he turns around, before he knows it, boom, they're hit. Doesn't have time to react. Doesn't have time to get the fishing boat out of the way. It happens so fast. And this impairment is still showing 2 hours later, when he doesn't recall a lot of things. He's not sure if he fell to Lieutenant Johnson. He had hit this boat so hard that it blew a big, fat hole in the hull of his boat, or the port side of his boat that you saw in all the pictures, and you don't recall if you fell. You don't recall if you got jolted. And he's not sure if he said anything. He's confused. So this impairment goes on for this almost 2 hours later. He's confused. He's not sure if he said anything. He calls his friend Andy right away. He admits that he hit something and it wasn't good. And remember what Andy says, that as they're going to the rescue, after they've already been told by the neighbor, hey, turn on the music, you hear something out in the lake. They turn on the music, they hear the help. So they're all jumping in their boats and they're going to go help. He gets a call from the defendant. Not when he gets home, not 20 minutes later, on the way to that rescue scene. And he says, I hit something. It wasn't good. Now, he doesn't tell the police that he called his friend Andy. He doesn't tell the police that he talked to these other people. He's sure about having beer that night to Lieutenant Johnson, but doesn't mention anything else. He can't remember certain details. Even today's testimony, he can remember every single detail up until when he crashed his boat into their boat. And remember every single detail after he crashed his boat into their, but doesn't remember the crash. Even after talking with his wife for an hour about what happened before calling the police, talking about that it's a boat, Lieutenant Johnson gets there and he still says it's a rock. After his wife said he never said a rock before he got there. Is that memory loss? Is that confusion? Or is it impairment? It's impairment. Finally, his wife calls 911. He doesn't want to call, and it sure doesn't sound like he wants to call, because you hear on that 911 recording, you hear they start recording their voices prior to 911 pickup. And she tries to assure him, we just have to tell the truth. We just have to tell the truth. It doesn't sound like he wants to call at all. He doesn't take the phone from his wife and call on his own. They don't call 911 as soon as they get there. And he never reports the shots that he takes at the bar. He has 2 hours to come up with a story, and he can't remember even stopping. But he does know, when Lieutenant Johnson gets there, that this is going to ruin his life. What about Brian's life? What about Brian's family? And what about Bruce, having to see his best friend fishing with die? Now, 2 years later, he even comes up with some story that's even more different than what he told Lieutenant Johnson. Remember what he said today and then. He was familiar with the lake. He should know that fishing boats are commonly out there. He doesn't recall seeing any fishing boats on the way up to the campground or any other boats, but they were probably there, he had to admit. Now, when he comes back, he's seen boats out there. He should know to look out for any other boats. Everyone else was consistent with that. It's a common occurrence on that lake for boaters to be fishing at night, for fishermen to be out on the shore, and for people to have lanterns. He says he doesn't see the lights because he's impaired at the time. To Lieutenant Johnson, he never saw any lights, but today he saw some bridge lights. Remember that everyone testified they remember seeing the lights, and they remember seeing other people fishing on the shore with lights, and they remember seeing the lights in the fishing boat being on. Testing also said that the lights were working. Those fishing boat lights worked. Scientific testing said that the bulbs were working. And a further test of that front light on the fishing boat, the one that would have been into the bayliner, the side that would have penetrated the bayliner at that point, was on during the crash. Because remember, Susan from BCI says the light in the front was definitely on because it showed that deformation. That she could tell it was on because it was as long as it's within 3 feet of an impact, they can say whether it's on or off during that impact. Now, remember, she doesn't know how long this boat is, but we know from the testimony that it's 16 feet long. And she couldn't say with that backlight definitively that the large filament was on, but she could say that the small filament was definitely on. And that's about 13 feet from the impact. We also had to prove beyond a reasonable doubt that the defendant caused the death of Brian. I already talked about the impact that this had on the fishing boat, the instant violent force, and Dr. Dean testified that Brian died from blunt force trauma to the head. Such force that it broke his neck, and we know he's on the front of the bass tracker. His teeth and his hair get slammed into the bow of the bayliner, and it was fast and it was violent. The defendant also caused serious physical harm to Bruce Lindewood. The same collision that caused Bruce to fly into the water, the same collision that caused Brian to be killed, Bruce was tossed about and sustained injury to his arm. He still had some muscle damage, he still has pain, and he had to undergo physical therapy. Multiple witnesses also talked about Bruce's arm bleeding when he was towed into the docks and at lessons, or when being put up into the ambulance. The defendant was reckless as well. His impairment caused him to act reckless. This affected his ability to operate the vehicle in a safe and responsible manner as outlined in the law. The ODNR guys and even Mr. Bean talked about the fallback to all of these navigation rules and that a boater must be responsible. He must look out for other things in the water. He must act in a safe and responsible manner. And our expert talked about the boat planing at the time of impact. This boat was going fast by even the defendant's admission. He says he's going 25. Although that could be higher or that could be lower, but we know it's planing because of the location of the hole in the side of the port side of the bayliner and the direction of the gash. The impact to the bayliner is apparent. You could see directly through that port side bow up through to the hole where the drink holder is. This would not have happened if the defendant was going the speed limit. This would not have happened if the defendant was slowing down in order to obey that no wake zone underneath the causeway. He may have hit the bass tracker but not sustained that amount of damage. If he wasn't so reckless, he would have seen the bass tracker and had time to avoid the crash. If he had seen the bass tracker, he would have been keeping a proper lookout, which they all testified that he was failing to do. And he has a duty. If those boats, as we've been testified to, If he is the stand-on vessel, meaning he has sort of the right-of-way to the bass tracker, and he sees that the bass tracker is not moving, then he has a duty to move his boat, to go around it in order to avoid a collision, and he didn't do that in this case. If he was going the speed limit, he would have seen that the bass tracker was standing still, and he didn't. Knowing that an accident occurred on the waters of the state, the defendant knew right away that he hit something. He left the scene of that accident not because he was disoriented from the accident, but because he knew he did something wrong. He's a doctor. He's drank alcohol before. He knows that his blood is going to have alcohol in it, as he tells Lieutenant Johnson. And he knew that right away, and he ran away.
Sustained.
He also called Andy right away. We talked about that. He yelled at Bruce in the water. He didn't stay and help. He didn't stay and offer any assistance. He didn't stay and offer his information as the law requires in Count 5. He cowardly goes full throttle home so that he could figure out what to do. You recall, I've already talked about Beston Cease talking about how fast he was coming under the causeway, and that he had mentioned to his friend that that guy's going to kill somebody. He waits until he gets more information on the phone before him and his wife, or just his wife, calls 911. This is almost 2 hours later. Your Honor, the defendant did operate or was in physical control of a watercraft underway on the waters of this state while at the time he was under the influence of alcohol. He did, while operating a watercraft, cause the death of Neil Puckett as a proximate result of committing a violation of the DUI, that 1547-11. He did, while operating a watercraft, cause serious physical harm to Bruce Lindemood as a proximate result of committing a violation of 1547-11. And defendant, knowing that an accident or collision with persons or property on the waters of the state, failed to immediately stop the vessel at the scene of the accident or collision to the extent that it is safe, and failed to remain at the scene until he gave his information to the operator. The defendant is guilty, beyond a reasonable doubt, of all of these, Your Honor, and we've proven each and every element of those offenses. However, as I've stated before, if you find the defendant was not under the influence of alcohol, I ask you to consider the lesser included offense of reckless. You can determine from looking at all the evidence that the defendant was definitely reckless in this case. He acted with heedless indifference to the consequences. He perversely disregarded a known risk that such circumstances are likely to exist. And that's only if that's that failure to prove that OVI, the DUI portion of that section. Your Honor, I'd ask you to look at all the evidence, recall all the testimony that you've heard, whether it's from other fishermen, other people at the campground, Mr. Lindemood, any of the police agencies, any of the BCI. Recall their testimony in looking at the evidence and find the defendant guilty of all counts as charged beyond a reasonable doubt. Thank you.
Thank you. Attorney Morrow.
Thank you, Your Honor. May it please the court, counsel. Beyond a reasonable doubt, you'll be glad to know I'm not going to go through Mr. Uhas's history of how that standard was developed and what happened in England before our founding fathers came here. You know, it means you have to be firmly convinced of the proof of the charges that the government has brought against Joe Yurich. They know, and they've known since the inception of our country, that that burden is theirs. Nothing unique, nothing new. Despite that, not one official from any of all those police agencies you've heard, not ODNR, not Mahoney County Sheriff, not Deerfield, none of them took one measurement to determine how far the campground was from somewhere where the scene of the accident may have been, not one measurement to determine how wide this lake is, how wide this bridge is, how far the accident was from the bridge. Not one person from any agency tested to see if those lights on the Bass Tracker that night were visible in compliance with Ohio law. Beer can on the boat? Hundreds of pictures on that disc for you, well over 300. You will not find one picture of a beer can in Joe's boat that day. No, I submit to you that they have not come up with proof beyond a reasonable doubt. They did not take reasonable steps to conclude what the true cause of this accident was and what contributing factors were. Rather, the state starts out with an opening statement saying, you're going to hear Joe was drinking in the afternoon, got on his boat, did more drinking, went to the dock, did more drinking, went to Ben's, did more drinking, came back. You didn't hear that evidence. That's a nice soundbite to try and get people to think he was drinking that much. That's not the evidence presented in this case. The state wants you to believe that Joe Yurich, 220 to 230 pounds, who had approximately 3 beers and too many beers, was impaired. Despite the fact that everybody who came in contact with him before he stepped on that boat to leave says otherwise. The state wants you to believe that he was impaired and that the one person who came in contact with him from law enforcement after this accident concluded otherwise multiple times. The state wants you to believe because Joe was impaired because he didn't see lights on this boat before impact. Well, then every other person who came from this side of the lake, the fishing boat to come help, these boats that came down, this person that saw it from this angle, the people that saw it up on the bridge, all said those lights were hard to see. In fact, some of the witnesses said, the one witness said, I didn't see any lights before the impact. She was over here. I saw lights on the boat after, on the fishing boat. The state wants you to believe that because Joe Yurich can't remember what happened when he heard that impact, he was impaired. Multiple witnesses described it as an explosion. And somehow the state wants you to negate what went on in Joe's mind at that moment. They want you to ignore it. You heard his testimony. You heard his experience. And he told you when that explosion occurred what happened in his mind. Euripides, a Greek tragedy writer and philosopher, said, man's most valuable trait is a judicious sense of what not to believe. What the state told you in opening statements and what they want you to believe in this case, they have not proven beyond a reasonable doubt. There really are three main issues. Was Joe impaired? Lights on the Bass Tracker, and not just lights on the Bass Tracker, lights that complied with Ohio law that were operating and visible prior to the accident. And the third issue is the issue of speed. We know Joe wasn't impaired that night. Everybody that interacted with him before he got on the boat said he was fine. Not one person came in and gave you any indication, any hesitation on that. So we have him getting on the boat, and we know that in 5 minutes somebody comes down to the campground and said, "Did you guys hear that? Let's turn down the music." And that's when the boats take off. So within 5 minutes of the accident, we have witnesses confirming his condition. Rachel Mace from Ben's. She would be, as a bartender, a person who experiences people an awful lot drinking. When she was asked any signs of impairment, not only did she say no, she said absolutely not. Now you have the video from Ben's. And I will tell you, when you watch that video, there are some interesting things. The state wants to keep saying shots, shots, and even an opening statement mentioned this fireball. If you watch the video, you will see too many beers being poured. And we know there are many beers because you can see the bartender getting the heavy whipping cream and pouring it on top. But what's really interesting and what confirms that Joe was not out there just trying to celebrate and party it up, they sit down at the bar, and you can clearly see the bartender put 4 people at the bar, 4 beers. Nearly 12 minutes goes by before Joe ever takes his first sip. He's talking, he's watching the Cavs game, he's socializing with friends he has been out with for a while. He's not pounding beers back as soon as he sits down. So the disc from Ben's tells us he's not out having this big celebration. Are he and his friends a little animated? Yeah, and Joe told you he likes to talk. You'll see him high-fiving, you'll see what I would characterize as men being men. You don't see impairment. You can watch, because there's several camera angles as Joe leaves. He's still watching the Cavs game, he's walking, and he's texting. And he's doing just fine. No indication of impairment. Andy initially reported, Andy Crow, he testified here today that he thought they may have had 2 to 3 beers and 1 to 2 shots. He gave that statement to the police several days after the incident. The video confirms he was wrong. He was mistaken. Was he impaired when he was talking to the police that afternoon? He's the one who says it was a fireball. We know from the video it wasn't. Again, within a week after the accident, on video talking to the police. Was he impaired? The bartender, Rachel, she was pretty certain when she first started testifying that she was the one, that it was her daughter who poured that first beer for them, that first beer. And then when she looked at the video, she went, "Oh, no, that's me." When she testified initially on that stand, her recollection was wrong. Was she impaired? When you watch that video from Ben's, it shows an individual having a couple beers and a couple mini beers and leaving. What is clear from the government's case is that Lieutenant Johnson walked into this courtroom and tailored his testimony in an effort to try and get you to believe Joe was impaired. But when we know on the night of that accident, and as he's investigating, there's nothing in his report to indicate, obvious or otherwise, any signs of impairment. He told Joe, "I'm documenting, and I'm not going to pull out all the pictures. You saw the pictures down to the dock of the steps that are broken, of the dock that has planks missing." And he tells Joe, "I'm documenting this so people can't come back later and say you were drunk tonight." Joe responds to all questions appropriately. Lieutenant Johnson doesn't. Well, he doesn't do a lot. The state wanted to make a big deal while Joe was on the stand. Did you tell him this? Did you tell him that? Did you tell him this? The fact of the matter is, if you review that interview and you have an PDB, God bless you, Lieutenant Johnson doesn't ask any of those questions. He doesn't ask about distances. He doesn't ask about lights on the shore. He doesn't ask about what would be an obvious question for law enforcement when they hear, "I don't believe I said that, but I don't remember." There's no, "What do you mean you don't remember?" Why don't you remember? Not one question on that. No, Lieutenant Johnson documents. Even with the I don't remember, no signs of impairment.
Objection.
You may proceed.
Thank you. Johnson testifies there was no indication Joe was confused. So Joe tells him, I don't remember, and he still says, I didn't have any indication he was confused that night. But yet he never tries to confirm why. This isn't something Joe just now says. Joe said that night two things. When they're talking about the boat accident, I didn't see any lights. And when he's asked about what happened after and what he may have said, he said, I don't remember. Two things that didn't just come up in this courtroom today. Those were present on May 8th of 2015. I submit to you the state has not presented evidence of impairment, and the objective evidence that you have indicates there was none. The videos, the reports and records are being submitted to you. But remember that everybody who saw Joe leaving that night, Melissa, Adam, and Andy, all said they had no concerns about him getting anything. So we go to the issue of the lights. Remember at the beginning when I said to you, nobody did any measurements on distance here. And at one point in time, the state starts asking Miles Bean, well, did you do any measurements? Because nobody from our side has, so how about you? No, he didn't. But we know really, I don't know where this exhibit is. We know from the exhibit submitted, defendant's exhibit G.
Can you move the board?
Pardon me?
I can't see the exhibit with the board.
I thought you were saying this was too small. I apologize.
Sorry. Thank you.
This is defendant's exhibit G. Ford testified that 6,000 feet is a nautical mile. And the lighting requirements in Ohio, according to Ford, are 2 nautical miles for the back light, 1 nautical mile for the front. Not as Mr. McCullough testified, those are some Coast Guard regulations. You saw the regulation in the Ohio Administrative Code that requires that on all waterways in Ohio. So we have this legend here that says 2,000 feet. The legend seems to have gotten cut off on this picture when it was blown up. But we know from this picture that this is nearly a third. Clearly, if that's 2,000 feet on this map and you move it, you're well off. If you got out a compass and assessed the nautical mile on the lake, that's what you'd find. We know the lights on the backtracker were not in compliance with Ohio law because we know that when Dustin comes under the bridge to come help, he says you could see like a little light off in the distance, but you couldn't tell it was boat lights. And in fact, it's Dustin who tells us when you have lights out at night, it's hard to tell which lights are on the water and which ones are on the shore. Here's a kid who goes out fishing on that lake as well, and he recognizes that perception on a dark night of, is this a light reflecting a boat or is this a light on the shore from a lantern, can be difficult. I wonder if Dustin was okay. The state said in closing arguments that Miss Elliott testified those lights were on at the time of the impact. That's absolutely false. She repeatedly said, we can tell from hot shot that the light was on when an impact happened. And she specifically said on cross-examination she would not say the hot shot that was detected in these 2 lights was from this impact. All she could say it was an impact. And she admitted that lights will continue working after hot shock. So we have this front light, and it's in the box, and the rear light. And we know the front light has sustained hot shock. And what Miss Elliott from BSI told us was that bows are pretty unique in this, unlike a car, because as they go across the water, they're bouncing. And as they're coming into the dock, they're bouncing and hitting off the dock. And those types of movements can cause hot shock. So she could not say, and the state does not have proof from Ohio BCI that these lights were on at the time of impact. Now, what is interesting is the prosecutor is now saying, well, 3 feet from. We heard testimony from state's witnesses and defense witnesses regarding this initial impact, the boat swinging and, according to the state's witnesses, violently impacting on the starboard side. And now she wants to say, well, that light was feet back from the impact. Not one measurement done from the state to tell us from this impact here how far back that light was on the back. So that standard doesn't apply. We also know, BCI testified, that if that light on the back, the 360 all around, had fallen over in the impact, there would have been hot shock if it was on. There's only hot shock on the smaller filament, which nobody tested to see. If only that smaller filament was on, how far can you see? There's no hot shock to the larger filament, so we can't say that one was on or off at the time. What we can say is that nobody provided testimony that both lights were on. Simon Ford, who's on the bridge, says, I remember the bow light on, but I don't remember any other lights on. Two people say those lights were on, Mr. Lindemoon and Lena Craven. Now, I'm not going to go through her testimony. It was readily apparent that she tailored her testimony to an agenda that she had. Nowhere in her original statement is there any mention of throwing a life jacket. And no other witness testifies to that. But despite Deanna saying she could see lights, Simon Ford, who's standing right next to her, says it's so dark you can't see where the boat is after the collision. He gets out that telescoping flashlight that he has to try and find the boat. Jennifer Kingsley testified that it was so dark she could hear the crash, but she could not see the lights on the fishing boat. She remembers hearing yelling, and she only saw the lights after. All of the witnesses that testified, Jennifer, Dustin Cease, Simon Ford, Andy Krogan, Adam Krolka, Melissa, Chuck Martin, all say that it's very dark out there that night. All of those that went to assist afterwards testified to varying ranges, but they all conceded that as they were coming across this lake to help, they could not see lights on the fishing boat. Some said it was within 50 yards before they could see it. Some said 100 yards. But all said that until you got close to that boat, you could not see the lights on. When the boat came in that night, there is not, in all the hundreds of pictures, this is Defendant's Exhibit O. In all of the pictures, and that's pretty dark up there, this lantern is on. You do not see that white 360 all around light up in any pictures. It is not present in an upright position in any of them. In fact, Lieutenant Nolan testified. He couldn't recall. He didn't believe he called Lieutenant Johnson and told him, we're not sure these lights were on, and if they were on, we're not sure you could see them. Nolan didn't remember saying that. Johnson testified, yes, he got a call from Lieutenant Nolan, and when he hung up the phone, he turned to Joe and said, there's some concern here that these lights weren't even on tonight, and if they were, we don't know that you could have seen them. I wonder if Lieutenant Nolan was impaired. So, despite knowing that night that there's a concern has been raised. We don't know if these lights are on, and even if they were, could they be seen? Nothing is done to do any of the requirements to ensure, yes, this is the distance they can be seen at. Yes, they comply with Ohio law. The 911 calls come in, from my perspective, in two areas. The issue on what could be seen that night, the lights, and the issue of the timing of the accident. You have the 911 calls, listen to them. You've listened to many 911 calls in this courtroom, and they all start out the same way, with a computer making dinging noises, and then a computer-type voice saying, May 8th, 2015, 12:02 a.m. And then the call starts. That's not on most of these calls. The time, the date, nothing. Okay. But the state has the ability to get that printout of all the log calls that come in through 911. That's not before you either. Now, despite Attorney Johnson and Mr. McCullough saying, well, we set the time at 12:10 based on 911 calls, both of them admitted on cross-examination that they didn't remember hearing times on the calls, and they didn't have the call logs to tell them time. So I submit to you the time of 12:10 for this accident is not based on 911 calls and is not accurate. We'll get more into that in a minute. When you listen to these 911 calls, nobody says anything about yelling, screaming, fighting between Joe's boat and Mr. Lindemood and Mr. Cuppett's boat. The first call, what you hear, dispatch never answers. The phone rings and rings and rings. And what you hear is a woman yelling. Something about, in a very loud voice, get him off there. I don't know what he... And listen to it, because I had it written down, and I'm not sure I wrote it down correctly, so I'm not going to call it. Other than get him off there repeatedly being yelled, she never talks to 911. The third call, man in the background can be heard yelling as the woman is on that call. And it certainly sounds like he's saying, what the F are you doing? In that third call. We know there are people along that bridge. We know there are people along the shore. We know people are upset about this accident. And we know from the 911 calls that people are yelling. The fourth call, you can hear talking and yelling in the background again. You cannot discern what's being said. The fifth call, the caller identifies they're from Lakeside Campground. I can't see the boat. I can only hear the yelling. Lakeside is on this side where we took the blue cushion. The sixth call,
Objection. No one's testified to that.
Jennifer Kingston testified to the blue cushion in. She was at this side of the Lakeside.
I don't think she called it Lakeside.
Okay. We can find that out from the testimony. The sixth call is from Simon Ford. And as he's talking, he tells the 911 operator twice to hold on. The first time he tells her to hold on, he's yelling out to Bruce, help is coming. The second time, and this goes to the visibility of the boat, the second time he says to the 911 operator, hold on, he's telling somebody, no, go the other way. Now we know Simon and Dina Culver were the ones directing the fishing boat that came under the bridge. And we know from Simon yelling that he's telling them they're going the wrong way as they're looking for this boat. So, Mr. Lindemood says we're probably 50 to 100 yards from the bridge. They're on the bridge. The fishing boat comes up under, and at 50 to 100 yards, that fishing boat can't land. This is the light that is on the front of the bass truck. You have it actually back there. Not as easy to see on this picture, but you certainly can pick it up and look at it in the exhibits. This is the one that is on Joe's boat. I'm going to submit to you that when you look at the filament in that light that's been submitted from the front of the bass tracker, it is dark, it is opaque. And I suspect Lieutenant Nolan, when he saw it that night, thought, even if this was on, you're going to have trouble seeing it because the lenses are dark. We know there was a trolling motor on the front of that boat. This light is on. How do I put this light on? That makes it much easier. We know there was a trolling motor on the front of the boat, and you can see in some of the pictures the discolored carpet on the front where it was mounted. We know it's mounted along here, and we know it comes across this side of the boat. And it hangs down the wall. The state never did any measurements on that. The state never did anything to determine if when this trolling motor was on and across here, would it obstruct the vision for that front light. That light, by the way, gets sheared off, and there was testimony that it probably got sheared off by the trolling motor as it was pushed back. If you'll recall, the state's expert prepared these in the accident reconstruction. And we had a big board with this initial one from the ODNR report that seems to indicate, based on the testimony, Joe coming from the north, traveling south, and the bass tracker pretty much across as you would be heading down towards the bridge. This initial diagram has the bass tracker tilted slightly, facing the bridge, but tilted slightly. This one was not included in the final report from Mr. McCullough. This was his. And when I said, well, wait a minute. If the bass tracker was facing the bridge, something here isn't making sense. He said, well, this was just to get a perspective of the angles as the boats came together. Well, if we're trying to get a perspective of the boats coming together and the angles, and we know the bayliner is coming from the north, and you turn this so that the bayliner is coming from the north, the bass tracker is not facing the bridge. When you take this and actually transpose it to the angle that we know Joe's boat is coming from the north, and the angle where the bass tracker is, the bass tracker is not facing the bridge. It is facing sort of northwest. And we also know that to be true because when we did the digital reconstruction, Miles Beam came up with this same perspective on the angles. So, from the accident reconstruction that was done, Joe is coming from the north. Everybody testified he's coming from the north. He left the dock and is traveling down. And here's why this is important. Mr. Lindemann was in a traumatic accident where he is trying to figure out where his friend is, how he's doing. He has been injured. You heard him testify about being thrown into the water. You heard him testify about trying to, when it's dark out, how difficult that is. No one would expect him to give details with accuracy in those conditions. The accident reconstruction helps us because when we place the boats at the angles they're supposed to be at, Joe is over here in the driver's seat. Mr. Cuppett is here. Mr. Lindenwood is here. Mr. Lindenwood is in the back fishing seat. And behind him, if you look at the pictures, when the 360 like this, it is behind his seat at the angle that Joe would be in. And so is the ranger. So when we have the proper angles of where the trolling motor is, where Joe is seated, where the front bow light is, and where the positions of the back lights are, at those angles, those lights, even if they were on, could have easily been obstructed. The issue of speed. Mr. McCullough testified from accident reconstruction that speed could not be determined. Miles Beam testified that speed could not be determined because there's too many variables and factors we don't have the concrete information on. But we do know that night, Joe admitted, and despite the statement saying he said 25, he said 25, you have the tape. He says 20, first he says...
She was mentioning a tape.
The interviews?
No.
Okay, I thought we had it in evidence. I thought you would alter all of those during the Lieutenant Johnson. During that tape and during that interview, Lieutenant Johnson admitted on cross-examination that Joe says he was going 20 to 25 and then says no more than 25. So that's the speed range we're talking about. And that certainly is in excess of the speed limit. But this whole issue of whether the boat is on plane or not is pure speculation. Miles Beam testified you could not, to a reasonable degree of engineering certainty, conclude that this boat was on plane when the impact happened. And he explained that in conjunction with Mr. McCullough's testimony about low speed, transition speed, plane speed, and how there's not these bright defined lines. It is a progression. So you cannot say at this very moment, from looking at the evidence, that he had completed transition and come to plane speed. He also explained that the reason you can't is because the nature of this damage, the way the bow of the fishing boat went in is like that slice of pizza. And as it pushes in, it's going to distort what the line of the original impact was. So we don't have evidence, proof, based upon engineering and science, that this boat was on plane at the time of impact. We do know Joe admitted he was speeding that night. Failure to use reasonable care? Well, that would be the simple standard of negligence. We know from the testimony that when Joe left, he looked out and he didn't see any other boats or lights out there. And he testified, that as he came down the lake, he could see the horizon, and he used the bridge to guide him. And then prior to the impact, he does not see any other boats. He maintained a lookout, and he kept saying, look to the horizon, look across, and that's what he was doing that night. We know there were no other boats on this side of the lake other than the fishing boat that night at the time of impact. And how do we know that? Because when the impact occurred, it was loud enough so that people over here could hear it, people up here could hear it. No other boats came to help. The fishing boat that ultimately came to help came from down here. They were trying to find the railroad trusses. They were fishing here, came across, and went up. There were no other fishing boats or speedboats that came over to help here. Andy and Adam left their dock and came down. So when Joe says he looks across the lake and he doesn't see any boats, there's no other boats out there to see at that time other than the fishing boat. He thought he was proceeding in a reasonable manner. He did not think there was any other traffic on the lake that night. And when Adam and Andy get in their boats to go help, they testified there were no other boats around there until they got right to the bass trapper. And that's when they see the other fishing boat that was already helping. There was some testimony, and I believe Melissa provided it, that said when Joe left, he was driving too fast. But she and Adam and Andy said once he made that turn, one, they could not hear his engine anymore. So it didn't sound like he was still going really well. And two, they don't know what he did when he went around that cove. So they can only provide testimony to what was happening as he was pulling out. Now, the prosecutor wants to argue he was reckless in his driving. Well, you heard testimony about trees and stumps and even a barn silo that's under the water up here. There's no indication that Joe had any difficulty navigating around all those rocks, stumps, silos, and other debris. He didn't hit any boats as he was pulling out of that dock, and we know there were a bunch of other boats up at Andy's campsite, and we know that slip holds multiple other boats. So there's no indication he has trouble negotiating out of the dock. There's no indication he has any trouble negotiating out of the cove. He's not grounding himself. He's not hitting other objects along the waterway. He safely negotiates out to the middle and heads south. There's no indication from any of the testimony that he did anything other than speak. There's no evidence, as there is just like there is with the impairment issue, there's no evidence or testimony presented from the state who has the burden here to establish what they think reckless driving is and what they believe supports reckless driving. I told you about the 911 calls earlier and how there's no time on them and there's no printout here to establish time for this accident. The cell phone records confirm Angelina called him somewhere around 11:33, and he said, "I didn't get out of there as quickly as I wanted to because the other boat pulled up." So he doesn't leave right at 11:33. The other boat pulls in. And this is one of those red herring, makes no sense. Joe's not on any other boat that day. He's not with a group of other people racing around this lake, as indicated in opening and writing the code. He is out there with his wife, pregnant wife, and 10-month little baby, and they have lunch, they go out to the beach, they see a couple of friends, they come home, they make dinner, they get the portable playpen, portable sleepers set up, and then Joe gets a call from Andy. Defendant's Exhibit K, I had Andy probe and highlight his phone number. And that was for two reasons. One, so he didn't have to on camera tell the world what his phone number was. He was the one who didn't want to be on camera and didn't want his testimony being live streamed. So he highlighted his phone number. Go through the phone bill and see what the other calls to Andy Krogan are. Because between 9 and 12:09, I should say shortly after 9, Joe calls him and says, "I'm on my way over your place." Between that time and 12:09, there are no other calls to Andy. And we know this accident couldn't have happened at 12:09 because Angelina remembers looking at her cell phone when he pulled in and it said 12:05. But we have an independent witness, the gentleman who arrived to haul the boat out, Mr. Rich. He says, his report confirmed that he arrived at Less's and the boats were already there. The bass trapper was already there at 12:20. So what the state wants you to believe is that this accident happened at 12:09. Andy and Adam get down there, they get Mr. Cummett out of the water, the other fishing boat gets there, they go into the shore, all by 12:09. I'm sorry, all by 12:20 when the tow truck guy comes. Now, he knows the call didn't come in until right around midnight because he was sleeping. And it takes him at least 10 minutes to get to where Less's is. So he's sound asleep when the call gets in, gets up, gets dressed, gets in his truck, and goes to Less's to help. And that's at 12:20. There simply is no way, and the state hasn't presented any evidence to prove that this accident happened at 12:09. So the suggestion that when Joe makes that phone call to Andy at 12:09 is actually on the lake is unsupported and is ludicrous, and certainly hasn't been proven beyond a reasonable doubt. At 12:09, Joe was back at his dock. He had to find his, 12:05 he was back. He had to find his phone, could not find his glasses, and called Andy. So basically what the state's saying to you is, we've charged and indicted this man with operating his boat while impaired. We haven't presented any evidence of impairment, so if you don't buy the impairment, go with the reckless, because we think he was driving erratic. We don't have any witness or testimony to anything other than speed. So if you don't find that he was driving erratic, you should find he was on his cell phone at the time, and that should support reckless. Again, the state knew the burden of proof long before this case was ever indicted, and they simply have not presented facts to support, beyond a reasonable doubt, any of those scenarios. No one, whether it is the night of an accident or 2 years later when they come in here and testify, recalls things the same or with accuracy. We know when we see something that the way our mind works is our already preconceived information and notions we have impact what we see and how we recall it. So no, Lieutenant Nolan wasn't impaired when he said, no, I didn't call Lieutenant Johnson. No, Lieutenant Johnson wasn't impaired when he got the dates wrong as to when this accident happened and was certain that the dash cam on his car had to be wrong because that wasn't the right date. No, the bartender wasn't impaired when she walked in here and testified that she didn't serve that first beer. No. Witnesses that came in here gave their best recollection. And it didn't mean they were impaired when they couldn't remember or said something that was inaccurate. And I submit to you that the same is true with Joe. He answered questions the night of this incident with Lieutenant Johnson that were asked of him, and Lieutenant Johnson confirmed he was interacting in conversation and responding appropriately. So the state wants you to believe Joe was impaired because he didn't see any lights on the boat, when multiple other witnesses that were out there didn't see those lights either. A judicious sense of what not to believe. One of the greatest traits to have. I submit to you that based on what the prosecutor told you in opening statements their evidence was going to be, and what actually came out of this courtroom, confirms that Joe was not impaired when he got that boat that night, that he was speeding. That when the impact occurred, there was a loud explosion. Multiple witnesses confirmed that. And that when he heard that explosion, all he could remember was being in Iraq. And the same sense of fear, the same sense of what's going on, not hearing or seeing anything else came over him. And that when he got to the other end of the lake, he was scared and confused when he came over back here and needed to get home because he did not know if his boat had been damaged. And And when he went home, he started calling friends to try to find out what had happened. Because he did not remember, and does not remember. And he told Lieutenant Johnson that night that he did not remember. Failure to use reasonable care. When he left the cove, he was looking around, didn't see any boats, and thought he was driving reasonably. He should not have been speeding. But I submit to you that under the state Ohio's law,
Objection.
Basis.
Never mind.
we all do it. It like comes out of your mouth and then we go, why did I just do that? The definition of reckless is heedless indifference to the consequences. Heedless indifference means I know what the consequences are and I say, screw it, I'm doing it anyway. That's not what you have here. That's not what the facts presented have been. Joe knew coming out he needed to watch out for other boats, and he was. And given the evidence and testimony regarding the lights and when they were seen and whether or not they were even on at the time of impact, there is not sufficient evidence to support a conviction for heedless indifference. And let's look at the criminal negligence standard, which is different than the failure to use reasonable care. Substantial lapse from due care. The person fails to perceive or avoid a risk that the person's conduct may cause a certain result. Again, the evidence doesn't support that. You have testimony that he knew there could be boats out there, and he was keeping an eye out. And when he saw lights on the horizon, it is not an impairment issue. It is, as Dustin Cease said, and as Miles Bean said, that when you have those dark conditions and there's another light that's there, it can obscure the lights from the boat and appear to be one of the lights on the shore. In opening statements, Attorney Uhas told you that just a few years ago, this would have been a civil wrongful death lawsuit and not a criminal prosecution. Because there was failure to use reasonable care, and that negligence caused boating accident. But the state has not proved to you, beyond a reasonable doubt, the elements of impairment necessary to support a conviction for OVI. And as a result, they cannot obtain a conviction for aggravated vehicular homicide or aggravated vehicular assault. With regard to the leaving after the accident, you heard Joe's testimony. If you believe that when he heard that impact, in his mind, he was in Iraq, and that he didn't know he hit another boat, then the verdict has to be not guilty of that. Because it requires, under that statute, knowledge that an accident has happened, and stop it only as long as it's reasonable and feasible. It's not a problem to stop. So, the burden of proof is on the state long before this indictment came out. And they haven't presented facts to support the conviction. We ask that you enter a verdict of not guilty on each count of the indictment.
Thank you. Attorney Cantalese.
Thank you, Your Honor. Our burden of proof is beyond a reasonable doubt. Not beyond all doubt, as you know all too well. And it's only to those elements that are contained in these counts in the indictment. Not whether the lights were working, or how far you could see the lights, or the distance of the lake, or how far the boat was from the bridge. Because in the end, the defendant still killed Neil Cuppett. The defendant still caused serious physical harm to Bruce Lindemood. We don't have to prove a number of drinks. We have to prove he consumed alcohol. We have to prove it impaired him. And we definitely proved that. Lieutenant Johnson didn't say he wasn't intoxicated. Said the defendant wasn't highly intoxicated. He didn't see obvious signs of intoxication. And he didn't tailor that just for his testimony. That's in his report. It's always been the same in his report. He didn't tailor that was the meaning. Multiple witnesses described this collision as an explosion. The defendant never did. That day, he never told Lieutenant Johnson that he heard an explosion. Only today does it become an explosion because it would benefit him. He didn't say that to Johnson, and he didn't describe what happened while he was at the scene. But he did admit today that someone did offer him a ride home. He had been drinking at least 3 beers, 2 shots, and someone offers him a ride home. I think someone at that scene knew that he shouldn't be driving. They don't see impairment at Ben's restaurant. This is 9:45, and he's there for about an hour till around 10:45, and that's on the video. So as the bartender's initially serving him drinks and serving him those first few drinks, she doesn't see any impairment then. But to Lieutenant Johnson, he's sure to say he only had beer. He's asked specifically about other alcohol, and he says no. He doesn't tell Lieutenant Johnson about the little beers or the shots that he had at Ben's. The defense wants you to believe that because of these lights, that the defendant must not be responsible for causing the death of Neil Cuppett and the serious physical harm to Bruce Linden. These lights were on. Now, yes, Susan from BCI can't say that those lights are from that accident. She can't even say that those lights are from that boat. All she could say is what that tag tells her. You know how we do get to that? Based on the fact that Rich McCullough, Dave Ford take those lights from that boat immediately after the collision and have them tested. They also test the light sockets and find them working. And we know that that's more than 3 feet from the impact. Even those 3D designs show that. The initial impact is on the bow of the port side of that bay liner. And a lot of people testified that they saw those lights on when they saw the boats colliding, when they saw afterwards the fishermen yelling for help. And John Gersh, who's the volunteer fireman, says he was there when one of the firemen got into the boat because it was arcing, it was sparking a little bit, so they disconnected the battery, and saw that when they towed the boat in, the lights were still on. Now, he saw the lights, or he didn't see the lights, but he still killed someone. You know when it's hard to see detail when you're looking at something? When you're impaired. When he can't tell whether it's the lights from the horizon or the bridge, which is the first time we've heard that today, because when he talks to Lieutenant Johnson, he didn't see any lights. He didn't talk about seeing lights on the shore, he didn't talk about seeing lights on the boat. And he's impaired that night. He's already using bad judgment. He already says he's speeding. The time of this impact, this collision, is not part of the elements as well. So the time of this accident was testified to. You don't need the dispatch reports to corroborate that. If it was incorrect, the defense would have cross-examined them about that time. The defense wants to make a big deal about the victim, about stuff they did. Did they have their lights on? Were they in the middle of the lake? Did they move? Did they not move? It's not the victim's fault. It's not Neil Cuppett's fault that the doctor wanted to hurry home. He's not allowed to speed. Just because he's a doctor doesn't mean we have to get out of his way. They are 50 yards from the no-wake zone. So they already have a general idea of where this boat is. And no one said the lenses were too dark to see through. No one's testified to that. Then they want to talk about the trolling motor knocking the front light out. I guess that's the victim's fault too. Or the boat is not facing the right direction. Remember Bruce Lindemuth's testimony? He says he's facing the bridge. And that when Brian says something about this boat coming, he's facing the opposite direction and he has to turn around. That doesn't mean the boat's facing the bridge. It means his chair is facing the bridge. No one specifically asked him which way the boat was facing. Now it becomes that Bruce's head must have been blocking the light. But we know those lights are working. We know those lights are seen. There is some ability for Simon Ford and Dina Covert on the bridge to point the other fishing boat in the direction of that boat because they keep saying over there, because they're able to see the lights. And they're shining lights down on this other fishing boat that's coming through the causeway. The defendant is the one who had the duty to act in a safe and responsible manner. Now, speed could not be determined, but by his own admission, he's going 2.5 times the speed limit. He's rushing home. He's had a few drinks. Mr. Bean, the defense expert, had to admit that if that boat was in transition at the time that Neil Cuppett's boat or Bruce Lindemuth's boat penetrated that hull of the boat, that bow of the boat, it would be up 12 to 16 degrees. He couldn't find that angle. He even said that that top line was horizontal with the water, parallel with the water. Now, no one said that there weren't any other boats on the lake at the time. No one's testified to that. Now, whether the defendant didn't see any other boats doesn't mean that there weren't any other boats. He didn't see the victim's boat. He didn't have a lookout. And if the light causes reflection on the lake at night, he should be taking extra caution. Because he shouldn't be able to determine whether they're shore lights or whether they're lights from boats. He has to act in a reasonable manner. And remember, when Adam and Melissa talk about him leaving the docks right away, and then they don't hear the motor anymore after he turns the corner to get onto the lake. They have music going on. They're partying, they're having a good time, and it's not until one of the neighbors comes out and says, "Can you turn on the music? We think we heard something," that something is going on. With the timing of everyone being dispatched to that scene, which was testified to, there is no way that Angelina Rodriguez's phone or clock says 12:05 when the defendant gets home. He would have had to have been going 100 miles per hour if that's the case. The only person in this case that was impaired was the defendant. And he had 2 years to come up with a story. And it's only today that he heard explosions, and that he was reminded, and that he can't remember. But he remembers everything else. He remembers every single detail before the explosion, and he remembers every single detail after the explosion. And he remembers being scared. Yeah, he's scared because he just screwed up. Big time. He knows the consequences of what he did. If he truly thought he was going to sink in that boat, then he should have run it aground or found a dock close by. But no, he wanted to get home. He wanted to get out of there. Before the cops came and they found out he was impaired. Before he finds out he did run into a boat. Your Honor, after you review the evidence, I hope we'd submit that you find the defendant guilty, beyond a reasonable doubt, of each and every element of the offenses. Thank you.
Thank you. May I see counsel? For the record, I've indicated that I believe counsel has ensured that Kathy has all of the exhibits that have been admitted into evidence. Counsel is going to provide me with the case authority that's been cited prior to closing arguments, and as soon as I review those cases, I will retire to begin my deliberations. Thank you.
All rise. This court is in recess.
That's what you need.